Today, we will again dive deeper on Texas Senate Bill 140, which amended the Texas Deceptive Trade Practices Act to encompass and prohibit spam messages, which may be MMS messages, SMS messages, iMessages, WhatsApp messages, or even Facebook, Instagram, or X messages in certain cases to Texas residents effective September 1st, 2025, and more specifically cover what small and medium-sized business owners need to do now to comply with this new law, which is already in effect. My name is Chad Cummings, and I'm an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Texas Senate Bill 140, effective September 1st, 2025, introduces sweeping new requirements for businesses that transmit commercial text messages to Texas residents. These statutory amendments greatly expand the definition of telephone solicitation to include most forms of unsolicited promotional SMS, MMS, iMessage, and WhatsApp communications, creating substantial and ongoing compliance risks and litigation exposure for businesses that fail to meet the new standards. Senate Bill 140 does not simply prohibit spam. It creates a strict liability regime with treble, that's lawyer speak for triple damages, and attorney's fees available to aggrieved consumers, and in so doing, significantly raises the stakes for marketers, lead generators, and customer outreach teams. Compliance must be comprehensive, multi-layered, and defensible. More on that later. The law applies broadly to any business or individual that sends a commercial message to a Texas resident's mobile device, regardless of whether the sender is physically located in Texas. Think about that for just a moment. The key coverage trigger is the destination and recipient of the message, not the origin. A Texas area code alone is not determinative. The message must be received by a consumer who resides in Texas at the time of receipt to fall within the scope of the new law. Businesses that rely on national or outsourced marketing campaigns must immediately ensure that their vendors geofence campaigns or otherwise filter out Texas recipients unless strict compliance procedures are in place. To comply with SB 140, a business must satisfy multiple distinct ongoing obligations, each of which I will briefly explain. First and most fundamentally, the business must obtain as a prerequisite the consumer's prior express written consent before sending any promotional message. This consent must be specific, informed, and well documented. It must describe clearly the types of messages the consumer is agreeing to receive, including disclosures about frequency and use of automated systems. The consent must be given affirmatively, such as by checking an unchecked box or signing an electronic agreement. Pre-checked boxes, passive agreements, or terms buried in general privacy policies are unlikely to pass muster. The burden of proving that valid consent was obtained rests squarely on the business. Second, the business must provide the consumer with a functional and immediate method for opting out of future messages. This opt-out must be honored without delay. If a consumer replies with "stop," "unsubscribe," or a similar phrase, The business or its agent must immediately cease all future messages to that consumer. Continuing to message a consumer after opt out is not only a separate violation under Texas law, but also strong, compelling evidence of knowing or willful conduct under both state and federal statutes, potentially triggering those pesky treble damages. Third, businesses must comply with designated quiet hours during which commercial texts may not be sent. Under Texas law, solicitations made before 9 a.m. or after 9 p.m. local time on a weekday are prohibited entirely. And any messages sent on Sundays or on state holidays are similarly prohibited. Messages sent outside of these permitted windows, even if otherwise compliant, are deemed separate violations. The time of receipt on the consumer's device governs compliance, not the time of transmission. Businesses using automated systems must ensure that their campaigns are time zone sensitive and implement safeguards to avoid midnight or early morning delivery. Fourth, the business must maintain detailed records of all consent, opt out, and transmission data. These records should include IP addresses, timestamps, device logs, screenshots of the consent language shown to users, copies of opt in forms, and logs of each text sent and received. If that sounds like a lot, it is. This documentation must be preserved for at least 4 years and ideally longer. If litigation ensues, the absence of these detailed records will weigh heavily against the business or its agent and may lead to an adverse inference, spoliation sanctions, or even default judgment. Fifth, businesses must respect state and federal do not call lists. A consumer's inclusion on either registry, whether that is the National Do Not Call Registry or the Texas No Call List, creates a rebuttable presumption that any commercial communication is unauthorized unless the sender has specific evidence of valid consent. While it is theoretically possible for a consumer on a do not contact list to later provide valid written consent, the burden is extremely high, and the consent must be clear, unambiguous, and narrowly tailored. Businesses should routinely scrub their outbound lists against the latest do not call database dump and avoid messaging consumers on such lists absent explicit recent consent. Sixth, businesses must ensure that the identity of the sender is clearly and prominently displayed in every message. A generic message such as get 20% off today, followed by a URL or hyperlink without identifying the business name, very well may violate the law. Texas consumers must be able to immediately identify the sender and the nature of the goods or services being promoted. Failure to include such identification renders the message deceptive per se under the Texas Deceptive Trade Practices Act as recently amended. Seventh, third-party vendors and lead generators used by the business must also comply. The business is liable for the acts of its agents and affiliates. This includes marketing firms, call centers, software vendors, ad agencies, and any party who sends messages on behalf of the business. Contractual indemnities will likely not insulate the business from liability. Businesses, therefore, must audit their vendors for compliance, review their scripts and message templates, and require written warranties of legal compliance. It is not a defense that a vendor violated the law without the knowledge of the business. Texas law applies joint and several liability in many of these cases. Eighth, businesses should implement compliance training for all marketing personnel and customer-facing departments. These individuals must understand what constitutes a solicitation, which is a term of art, what triggers the quiet hours, and how to correctly and promptly process opt-outs and preserve adequate documentation. Every employee who interacts with consumers or handles messaging workflows should be trained annually on these requirements, if not more frequently, with written confirmation retained. Ninth, businesses must maintain internal do not contact lists. In addition to complying with state and national registries, each business must maintain its own list of consumers who have opted out of receiving messages. Once a consumer opts out, they must never be contacted again unless they reinitiate contact and provide new consent. This list must be updated in real time and applied across all departments and verticals. Failure to maintain and enforce this internal suppression list constitutes an independent violation under both Texas and federal law. 10th, and we still have a long way to go, so buckle up. Businesses must implement and test technical controls to prevent unauthorized or accidental transmissions. This includes rate limiting, duplicate suppression, time zone compliance, message throttling, error trapping, and fail safes to prevent repeated messages after opt out. Automated campaigns must be audited regularly, and vendor platforms must be validated for SB140 compliance. Remember, all of these requirements are above and beyond and in addition to the registration and surety bond requirements imposed by the Texas Secretary of State. If you are unclear about those requirements, please reference my earlier videos on this subject or schedule time to speak with me. Senate Bill 140 does contain a limited number of narrow exceptions. Political messages, non-commercial informational alerts such as regarding school closures or emergency notifications, and messages from registered nonprofit organizations soliciting solely for charitable purposes may fall outside the statute's coverage. However, the burden to establish exemption is extremely high and should not be assumed. Even within these narrow categories, if a message includes any offer of goods or services, even if it's just merely incidental to the message's core content, it may lose its exempt status in that case. Certain pre-existing business relationships may also offer limited protection, particularly if the consumer has made a recent purchase, engaged in an ongoing service, or has otherwise manifested an expectation of communication. However, this does not excuse the requirement for express written consent if the message is promotional in nature. Courts have consistently held that existing relationships do not automatically imply consent for marketing messages under either Texas law or federal law. In summary, compliance with SB 140 requires far more than merely avoiding the use of auto dialers or refraining from spamming. It is a comprehensive legal, technical, and operational undertaking that must be implemented across the entire business right away, not just the marketing department. The risks of non-compliance are substantial and include statutory damages, treble penalties, injunctions, attorneys' fees, and even class action exposure. Businesses that wish to market to Texas residents by text message must invest in robust legal review, vendor oversight, training, documentation, and internal processes designed to avoid becoming the next enforcement target. Don't be the low-hanging fruit. There is no safe harbor for ignorance, and the plaintiff's bar in Texas is already watching. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this important information or the content of any of my earlier productions, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and to perhaps even work with you very soon.